I'm Joseph Fetterman. I'm a criminal defense and family attorney with Worth Law Office here in the Oklahoma City office. For example, if it's your weekend, let's say you have weekend visitation. If it's your weekend and you go out and you got drunk and you were arrested and you were put in a 24-hour hold, well, where were the kids? Did you leave them with a babysitter? It's an argument that you'd have to defend that while you were on your visitation, you gave the kids to the babysitter. I mean, it happens. There might be a reason, but not one that you excused yourself from the situation, left them with a babysitter, and then were arrested for drinking, excessively. Um, but generally speaking, if that wasn't the case, if it wasn't your visitation time and you got overly drunk and then you got put in the drunk tank for 24 hours, um, your partner should might get a hold of that information. They would have to file a modification. They might do an emergency modification of the custody agreement, or they might just do a regular, but they would get themselves in front of a judge where they can explain their concern. And it goes back to just a concern. It is not another criminal element. It's not that they have to prove it beyond a reasonable doubt to a jury. They just have to prove to a court that they have a concern and that the safety of the children are at risk with that concern, and the court will err on the side of that concern. They want to protect the children. So that's when it goes back to the court will initiate some programs, require you to do something to show that there isn't a concern, that it was a one off situation, and that you have everything under control and it's not going to happen again. Some of the things that the court might put in place is bringing in DHS involvement. And DHS can incorporate several different programs. They can require hours of your time to be dedicated to proving this will not be a safety issue for your children. The court can limit your visitation. They can make it where it's supervised. They can make it painful where it can be only supervised visitation with a court approved supervisor. So now you're paying someone to watch you watch your kids. And it gets to become burdensome because not only does it cost money, but now you have to check with their schedule. And all that can come while the modification is being on hold. That it doesn't need that the modification doesn't need to be fully adjudicated. The court doesn't need to hear it all the way and make a final determination on the modification. So it's not your visitation weekend. You get arrested, you're on the hold for 24 hours, you get out of jail, and you go to work Monday and you get served a notice of modification. You show up to your hearing, your ex partner voices her concerns, and the court can put these into position without a final adjudication on the concern. They can do that, and then they can set a review for 3, 4, 5 months down the road to see how you're doing with adjusting to proving to the court that there is no safety worries, that the concern was okay, it was there, that happened, but it's a one-off and it won't happen. But now you just have 4 months of supervised visitation where you're paying a court-approved supervisor to watch you watch your kids on certain days that work for them but didn't work for you, and so it becomes a big old money drain for you. If you or someone you know needs an attorney, reach out to Joseph Fetterman with Worth Law Office here in Oklahoma City. Our phone number is 405 694 4609.